Good afternoon, it's Attorney Christian Zeller. It's October 16th, 2020, and I'm reporting from my home office. Now today I want to revisit the EB3 downgrade subject because I have received countless inquiries and comments since my last post on this subject a couple of weeks ago. Now by way of history, the October 2020 Visa Bulletin shows that employment-based EB3s for individuals from India and China have advanced significantly more than the EB2 category for those nationals. Now this means that many EB2 applicants' visa numbers would be current had they filed in the EB3 category. And this circumstance caused a rush to downgrade from EB2 to EB3 to take advantage of this visa numbers windfall within the EB3 category. And today, I'm sharing some important filing information when downgrading from EB2 to EB3. In other words, I want to talk about the caveats that you need to watch out about. First, now notwithstanding, of course, that your EB2 priority date has to be current in the EB3 category in order to downgrade, you have to make sure that you qualify otherwise for a downgrade from EB2 to EB3. For example, if you are an EB2 within the national interest waiver category or a national interest waiver physician, you cannot downgrade because you can only get your green card in the EB2 category. Number two, under no circumstance revoke or withdraw your previously filed I-140. Number three, your new EB3 I-140 must be treated as a new petition, not an amended petition. Do not check off that it is an amended petition in Part 2 of the I-140 application. Number four, make sure you include a cover sheet in which you very prominently indicate that you are filing a subsequent I-140. Show the EB3 classification there, make note of it, and let the officers at the USCIS know that you are seeking and state that the original labor certification is not attached because it was filed with your previous I-140 application. Number five, in Part 4 of the I-140 application, make sure you check yes to the question whether a previous application was filed on your behalf, because it has. And separately, as an addendum to the application, include the previous I-140's receipt number and state that the original labor certification had been filed with it. Number six, also in Part 4, check no to the question that you are not requesting the USCIS to obtain a duplicate perm from the Department of Labor. Number seven, it is imperative that you include additional evidence, such as your employer's ability to pay the profit wage beginning with the filing of the original perm application. Include a copy of the profit job offer, and of course, evidence that you actually qualified for the job. I know you've submitted all that with the original application, but you will need it in the downgrade petition. Number eight, include a copy of your I-140 EB2 approval notice. And if it's not been approved yet, then include a copy of the receipt notice evidencing that it is still pending. And finally, number nine, include a copy of the previously signed perm labor certification. So there you have it. That's your update on the EB3 downgrade and a few tips on how to go about it. And at this moment, I also take the opportunity to thank and credit the American Immigration Lawyers Association for their tips and practice advisory on this subject matter, as a lot of my knowledge, of course, is drawn from what they do disseminate. So again, this was the update on the EB3 downgrade. Look out for further updates down the road. And if you haven't subscribed yet to the Immigration Help Channel, make sure to subscribe to www.immigrationhelpchannel.com. Goodbye and see you next week.